The last presentation of the day with Erin McCartney. She is an associate at John Turco and Associates in Omaha. She was last year's NSBA Bankruptcy Section Chair, and her practice focuses on bankruptcy law. Thanks, Erin.
Okay. Hello, everyone. My name is Erin McCartney. And I'm here to talk to you today about bankruptcy fundamentals. Hopefully maybe bring some fun into the fundamental part, because I know in the last one up today it's going to be a little bit tough. And the subject matter is also pretty intricate, so I'm going to try and make it as simple as possible to give you some basics to kind of go away with. Maybe just some things to even know. If you see it out there, you know, hey, that's an issue, I know that's an issue, and I know why that's an issue, and I know I need to refer this person to somebody or at least have a conversation about this issue. I have been practicing bankruptcy law for 8 years, and I do primarily debtor side bankruptcy. I have done some creditor side bankruptcy, but primarily debtor side. So just out of curiosity, does anybody in here have any experience with bankruptcy class, things like that? Well, you probably know more than I actually knew when I started. I had no idea what anything had to do with bankruptcy law. I didn't know anything about it, and so it was a hard start. But I think you know, getting through the process and learning along the years has been kind of a fun thing. And you know, most people, when I meet with them initially, they don't realize that bankruptcy is a legal matter at all. Even, you know, they come in thinking, I have to file bankruptcy. What do? I declare bankruptcy. Well, it's not that simple. But I wanted to show you a clip of something commonly perceived.
I declare bankruptcy! I just wanted you to know that you can't just say the word bankruptcy and expect anything to happen. I didn't say it, I declared it. Still, it's not anything.
It's not enough. So, but you would be surprised how many actual clients think that's all it takes. I'm sorry.
And welcome back. Well, filing for bankruptcy can be embarrassing and humbling, and many times
keep listening to those videos. Okay. From the beginning. Okay. So let me just. But actually, it's a lot more than that. It's a federal court proceeding. It's designed to give you an individual a way of discharging debt or reorganizing debt. It also provides a fresh start to individuals that need it in the hopes of becoming in a better financial situation. Unlike a lot of things in life, you know, financial situations, there's a solution, a possible solution. Unlike health issues and things like that, there is a way out. And a lot of people that come to you looking for bankruptcy advice don't realize it, and they think that they're forever in this horrible situation and never going to be able to find a way out. And so I often tell my clients, you know, hey, we're looking for more of a controlled crash landing, maybe not a fiery, horrific crash, which can sometimes happen if they don't seek advice in a timely fashion, where now there's liens placed on homes and garnishments and things like that. So that's just something to be aware of. I think in order to be a good advocate for your client, you need to know who the parties are in a bankruptcy setting. So here are some of the main parties that you would want to know. The debtor is obviously the individual who's going to be filing a bankruptcy. They're looking for some sort of relief. A creditor is somebody who holds a claim, either secured, meaning a mortgage or a lien on a title, unsecured credit card medical debt, or a priority claim, which would be taxes or a domestic support obligation. The United States Trustee's Office. This office is actually the big dog. They review filings for eligibility of matters of investigation, fraud, things like that can be prosecuted. It's serious, and I actually recently had a client call and say, oh my gosh, Erin, I have to talk to you. I just have this horrible feeling. And it was all due to the fact of that New Jersey housewife that got put in jail for bankruptcy fraud. Suddenly all my clients think they've done all these things wrong. I'm like, wait a minute, you guys, we're okay. It's been a thing all along, but now you know about it. The trustee, an appointed trustee in a bankruptcy case is from the United States Trustee's Office. They're appointed to each case to administer the estate, either in a Chapter 7 by liquidating assets and administering to the distributions to the creditors, or in a Chapter 13 taking the funds in and redistributing to creditors, which we'll talk about in a little bit. And then there's the bankruptcy judge. The bankruptcy judge is actually independent of the United States Trustee's Office. He or she is the one who will be reviewing matters that are disputed and then issue rulings on those disputed matters. So we'll talk a little bit about that too. In Nebraska right now there's only one bankruptcy judge. There are 3 sitting by designation that are used as needed if the caseload becomes too much. So knowing your parties is huge. Like I said, I mean, if you know who you're dealing with, you know the trustee you're going to be seeing, you know the judge that you're going to be seeing, then you're going to know how better to advocate for your client, what that individual party wants to see in your petition, all of those things. So like I said, know who you're dealing with. It's extremely important. Even the creditors, to some degree, you want to make sure you know which creditors are involved, because like I could say, hey, I know you have First National Bank and I know what they're going to do. So then you know better what to tell your clients as well. Like most areas of law, bankruptcy has its own code. And as you can see here, I kind of just individualized these out based on the title. Title 11 is referred to the code. Title 18 is crimes. Title 26 is tax implications. Title 28 is jurisdiction. The bankruptcy code has been amended several times over the years. The big overhaul was in 2005, where the Bankruptcy Abuse Prevention and Consumer Protection Act was created. It just basically made it a little bit more difficult for individuals to file. It also started the means test, which I'll go through with you in a little bit. So that's just something to be aware of. There is a huge intertwinement between federal and state law in a bankruptcy setting. And so federal law, you're going to look towards the bankruptcy code for procedural things, for actionable items, things like that. And state law is applied when determining rights in items like that. I'm constantly researching state statutes for, the validity of a lien, or, what does it mean if there's a future interest in Nebraska, and what kind of interest does that individual hold, things like that. And other presenters today have mentioned to you local rules. Local rules apply here too. Local rules are actually very useful in Nebraska because they kind of help dictate best practices and procedural issues for Nebraska practice. There are no local rules in Iowa, so just got to know your jurisdiction, know if there are local rules, where to look, where to find out. I put a link for you here, so that's easy for you to find those if you need them. And also, everybody that you talk to that practices bankruptcy, if you ask them a question, they're going to say, did you look in the local rules? It's like, yeah, I'll look in the local rules. Okay. So next, I wanted to kind of just go over a overview. In most areas of law, there's a huge intersection with bankruptcy law with a lot of other areas of law. And so some of you practicing attorneys know, hey, yeah, I know family law is one of the biggest ones, because what goes hand in hand with a divorce is potentially a bankruptcy. And so knowing, some areas of that law is extremely instrumental in bankruptcy too. Family law, of course, property settlements versus support obligations, those can be a big issue on what's going to be considered dischargeable. A lot of people don't realize. They come into my office and they say, well, no, my ex was ordered to pay that. Well, are you on the debt? Well, yeah, but I wasn't assigned that debt. Well, is your ex paying on that debt? No. Well, you're going to be the one they're going to come after. I don't care what your divorce decree says. It's still your responsibility. So it's something that people don't realize. They think that they can give a divorce decree to creditors and the creditors are going to go away. That's not the case. And so it's unfortunate that, sometimes people come to the hard realization in that way. Real property, obviously, any interest in any property is going to be a huge issue for a bankruptcy setting. And so you want to know the differences, what to document those differences are on a petition for the trustee, so that they know that you've done the work to find out. Contracts, the validity of a lien is huge. You got to make sure that they perfected their liens. If you think that there's a secured lien holder, make sure they took the steps to perfect those liens. Wills and trusts, I've learned so much about just the validity of a spend-through provision in a trust. So those things are important. Corporate and business associations, also extremely important. A lot of individuals that file bankruptcies are natural risk takers. They're business owners, a lot of them, and have come to this situation because of the fact that they took the risk to own their own business. Now, were they a sole proprietor, or did they incorporate? What were they? Can be a huge difference on what options you're going to give them in a bankruptcy setting. And finally, we're in taxation. I mean, taxation is one of those things where, you know, a lot of people have different types of taxes that they owe, and the dischargeability of the different types is income, sales, those types of things. You're going to want to know the difference between those. And so that's just an overview of the intersection of some of the areas of law and bankruptcy, just so that you're aware how much it kind of can touch on, and you know, where you're looking for certain things. Like I saw in a previous presentation, the case progression in our office is not always the same in every other office out there, but it starts with an initial consultation. That individual looking for help comes to you. You learn a lot about that individual at that initial consultation, and so that's when you set the game plan. You tell them what they're going to need to do to file, things like that. Next, I have on here is a pre-filing credit counseling requirement. Congress requires everybody who files a bankruptcy to take a class. It is offered online now, so it's easy, but it is required and must be completed. Next, you collect materials and prepare a petition. The petition is the biggest single piece of documentation that you can prepare for your client to give them the best outcome, which we'll kind of go through that in a little bit. Follow-up signing appointment. That signing appointment is where you finalize everything. Oftentimes, this follow-up signing appointment is where a lot of things come out that you didn't know were going to come out, and so you want to make sure that everything is ready to go at that time. Next, there's something called the 341 hearing, which is just a meeting of creditors. It's the chance for the creditors to show up and ask the individual questions. Normally, you don't see a lot of creditors at these hearings, although every once in a while you see like the IRS or the angry ex-spouses always like to show up to these hearings, so gotta watch out. Next, then the individual will be required to take another class. It's called financial management, again online. And in between this time frame, you're going to have judge involvement if needed, meaning that if there is a disputed issue, the judge will then make a ruling on that issue. So either between the trustee and the debtor, the trustee and a creditor, or the debtor and the creditor, all these parties have disputes, then those matters will go before the judge. And finally, if everything goes as planned, you get discharged. The individual will then obtain a discharge and they're no longer legally liable for the debt. So next, you know, the most important thing that you need to know when you're preparing a bankruptcy petition is what's called the bankruptcy estate. When a case is commenced, everything that debtor owns is part of a bankruptcy estate and must be disclosed. Even those things that are considered excluded from the bankruptcy estate, I routinely will just disclose for just full disclosure purposes. Even though I don't think it's part of the estate, it's going to be on that petition. All assets are listed, like I said, and some assets are going to be subject to exemptions, meaning that they're safe from creditor collections. There are federal exemptions under the code, and then the code also provides for opt-out options for the states. So the states can opt out of the federal bankruptcy or the federal exemptions and use their own state exemptions. Nebraska has opted out, so has Iowa. And so I just kind of gave you an idea. These exemptions protecting the assets from those creditors. A homestead exemption in Nebraska is $60,000. Tool of the trade exemption in Nebraska is $2,400. It's applicable towards vehicles. It is the only vehicle exemption in Nebraska. In Iowa, there is a separate vehicle exemption that can exempt a vehicle separate of a tool of the trade. A tool of the trade is a term used in the federal bankruptcy code for lien avoidance, which we'll get to in a little bit. Clothing is an unlimited exemption. Household goods up to $1,500 for individual, $3,000 for joint, and then the wild card exemption. A wild card exemption I can use on anything I want. So bank accounts, if there's some equity left on a vehicle that I couldn't protect, I'm going to use that wild card exemption. Some states have great exemptions. Some states don't have very great exemptions. California, I mean, you kind of can keep anything you own. So it depends on where you're operating, what their exemptions are. I always am happy when I see a client come in that they just moved from California. I'm like, yes, I have California exemptions, meaning you're not going to lose anything. So that's just something to be aware of. And you'll know when you're looking into these state statutes, if they've opted out, what those exemptions are going to be. So the bankruptcy estate's one thing that you need to be aware of. In order to know that your petition is prepared accurately and that your bankruptcy estate has fully been disclosed, is to provide full disclosure. Unlike a lot of areas of law, which you might say strategically you want to pick this fact and that fact and these things to present for your argument for your client. You don't have that luxury in a bankruptcy setting. Everything is full disclosure. Honesty is the best policy, the only policy in a bankruptcy setting, because of the fact that unlike some individuals going through legal matters, this individual, a debtor filing a bankruptcy, is asking for relief. They're asking for help. And so they are required to provide full disclosure. As an attorney representing a debtor, it's difficult because you're helping them work to disclose the things that they don't even know they need to disclose. So they don't know enough about what they need to actually even tell you, so you're doing a lot of the investigating for them. So it's your job to help them, to find out what they need to disclose. You want to disclose all the facts, because in my experience, inevitably, either those things come out eventually, or it's something that would change completely my advice to this person. So, for instance, I had a lady, she came in, we had the initial consultation, we went through everything, she came back, brought all her paperwork, my paralegal did her petition, everything was fine. We come in for the follow-up appointment where we're finalizing everything, and I say, you know, hey, do you have any interest in real estate? No. Okay, no lots of land, no center near plots, nothing? No. Okay, good. So things people don't think of. Does anybody owe you any money? No. Okay. Do you have any reason to believe you get an inheritance? Well, no, but I have some, my dad has farmland. Okay, well, where's that? And she tells me it's Iowa farmland. I'm like, oh, okay, well, what's it worth? I mean, is there a trust? What's the situation? Oh, no, I think he put it in my name. Okay, so your dad has farmland and now it's in your name. We have to stop right now. You need to go call your father and let's find out what this is all about. And in fact, her dad had put the land in her name, which totally would have changed my advice to her on what she should have done in that scenario. And so we did kind of chart her path a little bit. But it wasn't like she was trying to hide anything. She just didn't know enough to make it an issue. And it wasn't until I said, I can't file your case until we get an answer on this, that she was like, oh, I'll call him and find out, you know. So something to keep in mind, that can happen. There's so many examples about that. That's just one that stuck in my mind for some reason. So along with full disclosure, the attorney, unfortunately, has a lot of required acts. So due diligence on the part of a debtor's attorney is huge. It's strict requirements on all bankruptcy attorneys. The code provides for it. And again, in my experience, it's best to do this due diligence ahead of time. Instead of having to find out about these things and then backpedaling, it's better just to do it to start. So as you can see, the paperwork that we provide, pay stubs, bank statements, tax returns, those things might be obvious. The same with the list of assets and liabilities. Other things that might not be an obvious pick, like life insurance and in retirement account statements, I put on here because it's always the case that a client says, I have a term life insurance policy. Okay, well, let me see the paperwork. No, that's not a term life insurance policy. That's a whole life insurance policy. Or, you know, I have a 403B, and I look at it and it's not. You know, so you want to make sure for your petition accuracy that you can show what it actually is, because then you're also showing the trustee, the U.S. trustee's office, that you've done your due diligence, you've looked at their documentation, and you know exactly what they have, even if they might testify like, I don't have that. Well, yeah, you do. You have that. And so what I put on here is that you get all this paperwork, and then you would go through and research and verify everything, pulling the credit report and asset check. You can get those on Lexis and Westlaw. Pacer check for prior bankruptcies, justice check for lawsuits, UCC liens, judgment liens, the county assessor, I always check, see if they're behind on their taxes, and then Kelley Blue Book. That way, you know, hey, I know that I got the value of that vehicle based on Kelley Blue Book, and I always put it directly in the petition. Value based on Kelley Blue Book as in good condition, and then they know. There's no question. They don't even have to ask the debtor any questions. So that's just something to be aware of. And this is further driven into a debtor's attorney because now they do, and they have done, outside audits, which means that the U.S. trustee's office goes and finds an audit company to come in and audit your case. And so what they're going to do is look for the same things that you've already done. They're going to do an audit on the bank accounts. They're going to be looking at these statements. I think they Google, Facebook these people. I don't know how they find some of this stuff out. But what they're really looking forward to is a material misstatement. A material misstatement changes the outcome of the case in some capacity. So these are extremely detailed. It can be quite painful. I've had 3 of them, and thankfully none of them have been material misstatements, but I think it's because I was crazy about the bank audits. You know, they say that these audits are random, but these cases were not, that you could have pinpointed, like that's a problematic case, and that's why I got picked for an audit, probably. Just maybe. No, for sure. So when an individual is ready to proceed with a bankruptcy, there are 2 different types of personal bankruptcy. There's a Chapter 7 and a Chapter 13. Most people that think of bankruptcy think of a Chapter 7. Chapter 7 is complete liquidation. Non-exempt assets are liquidated, used to pay creditors. It's a quick turnaround, runs 3 to 4 months. A lot of people ask me, what am I going to lose? Let's say everything's exempt. You're not going to lose anything. As long as you stay current on your house payments and current on your car payments, you won't lose those things. There is a threshold income, which we'll talk about, means test. You have to pass it in order to file a 7. So if you make too much money, you may not qualify for a 7, and you have to do a Chapter 13. You know, we see a lot of people come in for bankruptcy purposes, you know, loss of income, things like that, and so it's not uncommon that a Chapter 7 is something that, you know, can be a useful tool. I actually have elderly people that come in and they've never missed a payment on their credit cards, always been current, never had an issue, and then suddenly the credit card company lowers their balance and raises their interest rate, and they can't afford the minimum payment suddenly. So now we have to, you know, do something to help them. So there's a lot of need out there, and some, you know, not obviously not the kind that you think of. These people are in desperate situations, medical, loss of spouse, things like that they can't control. So it's really difficult. You're dealing with these people at the stages of, you know, of extreme turmoil. So having to tell them that they make too much money and that they're going to be in a Chapter 13 for 3 to 5 years is a difficult place to be when that happens. But there are reasons that a Chapter 13 can be a great tool. Let's say they're behind on their house payments and they're going to be facing foreclosure. Chapter 13 will give them the option of bringing their payments current as long as they're able to feasibly be able to make the payments. Chapter 13 also gives you a super discharge, which is kind of neat because you can get a bigger discharge on certain debts, which I'll go through with you in a little bit. And then it also there's limitations on Chapter 13s that can cause problems, debt limits. So if they have too much debt, you might not even be able to do a 13, which then you're in Chapter 11. So just something to be aware of. You know, if you're in the situation where somebody's coming to you for advice, then you'll know, hey, these things can be issues, so we should talk about that. So how do you know if they qualify for a Chapter 7? Well, in 2005, the Congress created what's called the means test. The means test is a sliding scale based on income and based on the number of people in your household. So if an individual comes into the office and says, I make X amount and I have this many people in my house, you know, what do I do? What's my option? I'm saying, well, let me think about this, because if you pass that means test, then all I'm looking for are non-exempt assets. Because if you don't have anything non-exempt and you're below the threshold, below median, what they call, then you qualify for a 7. So the means test, like I said, was designed to give a way to determine who should be allowed to file a Chapter 7, and if they're above the threshold income, the median income for that family size, then it also gives you what's called the disposable monthly income. This formula was created to do both those things, you know, and so the means test will do both. And if you're above the median income and the Chapter 13 is the only option, then like I said, it will give you the disposable monthly income, which must be redistributed to creditors. The forms are all required to be filed with the petition for the means test. The one term that is used a lot that you might hear is, this case was filed with the presumption of abuse. And what that means is that basically that case was filed when an individual was over the threshold and there's some sort of disposable monthly income. You know, disposable monthly income means that there's some sort of presumption of abuse. You'll get a nasty letter from the U.S. trustee saying, you filed this case with the presumption of abuse. You explain to me why they should not be converted to a different type of bankruptcy. And so you get that. But, you know, mastering the means test is kind of a fun thing if you can do it, because it's a form of artwork in some ways. You know, the means test is going to say, purely we're going to look at the last 6 months of this person's income to determine if they qualify for a Chapter 7. Well, the last 6 months may not be indicative of the next 6 months. And so you're looking at a situation where you might want to recreate the means test so it fits your case. Let's say they're seasonal work or they get bonuses or commissions. There's ways to, I don't want to say doctor, but fix it so that you can accurately reflect their ongoing income or expected income. And so, like I said, it's kind of a form of artwork. I remember when I first started and I heard about this means test, and I was like, I just don't, I'm not going to get it. I'm not going to get it. Once I figured it out, I was so excited because I was so eager to figure out how I could do different things with it. That's probably not the goal, I guess, but just so you know. Anyway, here are the thresholds just so you have something to reference. A single individual over $43,000 a year may not qualify for a 7. And so that's just kind of, as you can see, it goes up with each individual added to the household. There are deductions you can take off somebody's income, and I'll just go through these with you briefly, but applicable living deductions, this is really the IRS standard of living costs. So that's not what they actually spend, it's already set amounts based on their household size. Actual expenses, you can deduct actual, that include taxes, child care, court-ordered payments, things like that. And then there's also deductions for debt payments and things. The special circumstances of change in income and expenses. This change in income or expenses, this is a new thing since December of 2014. It replaced kind of special circumstances, but this is what I'm talking about when if you wanted to go in, kind of change it a little bit so that you could reflect the actual income, that's where you're going to go. And I use that a lot. So I made this handy dandy flow chart. I hope it's helpful. It basically kind of tries to give you a diagram rather than wrapping your head around this all at once. It starts here, this means test, you're either above median. If you're above median, is there the presumption of abuse? If there's a presumption of abuse, you only have a Chapter 13. The duration is a mandatory 5-year plan, and you're going to have disposable monthly income show up on this formula to determine plan payments. If there's no presumption of abuse, then you can do a 7 or a 13. And there's reasons for that, depending on if there's equity in items that you can't protect, then 13 might be a better option. And then, of course, the below median, you automatically could qualify for a 7. But again, if you have non-exempt equity in the asset or you're behind on your house payments and you want to file Chapter 13, you can. The duration of the plan may be as low as 3 years, but up to 5 years again. And then the disposable monthly income is not factored in because there is no disposable monthly income on the means test. And so you use actual income and expenses. So it's kind of interesting. So we're about halfway through. And the first half of this presentation, I basically kind of wanted to go through bankruptcy, obviously the definition, the players, the code, the types of bankruptcy, the due diligence requirements on you as a practicing attorney, and the different types, Chapter 7, Chapter 13, and the means test. The second half of this is where I think it gets fun, but it's more the intricacies, the things that can be kind of powerful when it comes down to after a case is filed, what you can and cannot do, and some of the tools that people refer to. You'll hear these words a lot. And so I'm going to go through some of them with you, and just so that you're aware of them. First up, the power of the automatic stay. You hear the automatic stay. What's that? Well, it's a serious legal protection. It stops all actions at the time the case is filed. So as soon as the case is commenced, every collection effort is stopped. So garnishments, foreclosures, repossessions, the moment the bankruptcy petition is filed, it stops. It's not unheard of to kind of surprise creditors with this. I one time had a lady pull into the parking lot right behind her with the repo guy. We file, he's gone. So it's a powerful tool and can be used strategically if needed. There are exceptions to the automatic stay. I mean, there's still the possibility of being audited by the IRS. There's still collection of child support, and 401k loan repayments are still commenced. But mostly, I mean, it is the ultimate trump card. Okay, so it's pretty cool. Also, just so you know, this happens quite frequently. I know it seems surprising, but if somebody has filed a case, and let's say that case was pending within a year of filing a second bankruptcy proceeding, that individual who's filing their second case within a year is not entitled to the automatic stay automatically. So you have to file a motion to extend the automatic stay. And most of the time, as long as you have reasonable need for the automatic stay, the judge will grant that, but you got to give it a lot of substance. You can't just file a motion saying we need this. No, it's got to be that they're going to be garnished or something's going to happen. I file it every time there is a case pending within a year, even if there is no emergency. I'll file it showing due cause for change in circumstances of some sort. The funny thing is, in the entire time I've been practicing bankruptcy law, I've never had anybody object to an extension to the automatic stay, except for one time, and it was a very sensitive nature because I filed on the eve of a foreclosure sale date, and the creditor was Habitat for Humanity. And Habitat for Humanity filed an objection to my motion to extend the automatic stay. I did not want to be the one going up against Habitat for Humanity. Habitat for Humanity did not want to be the one objecting, but that's the way it came down. And the attorney I just talked to him the other day, he said, yeah, you remember that? And that was horrible. I'm like, yeah, it really was, because you just don't want to be in that position. But that was the one time that it happened, and I learned a lot from that because in my case, they were going to go after her because they said that she willfully disobeyed a court order in her previous bankruptcy. She didn't. She just didn't know the rules. You know, when somebody just doesn't know what they're supposed to do and the case was dismissed, then the judge will say, well, I'm going to give them a second chance. I'm not going to just say that they can't get that automatic stay. So that's just something to be aware of. Pending within a year, you want to watch out, extend the automatic stay. Okay, so this is one of the funner, I mean, I think this is the parts that get interesting. It's also a little bit more hard to comprehend. So these are things that I don't know that you necessarily will understand exactly what everything is involved in these, but the tools in a bankruptcy of what a debtor can do within a bankruptcy setting are kind of important and things that you should just know about. First, lien avoidance, then a lien strip, dischargeable tax debt, and the cram down. First up, lien avoidance. This one I have a special place for. Bankruptcy code allows an individual to remove liens in specific situations. This procedurally is done through a motion. So you file a motion to avoid a lien. And you need to make sure you have proper service on your creditors in this situation. But the elements to remove a lien in a bankruptcy setting. Number one, the lien must be a non-purchase security money interest. So it wasn't a lien that was placed because you used the money to buy the asset. Number two, an exemption must apply to this asset, either under federal statute or under the opt-out state exemptions. And number three, this asset must have been provided for under the federal bankruptcy code in some way. And there's really the three main categories of assets that are provided for under a lien avoidance under the federal bankruptcy code. That's number one, personal goods, which is limited to this here, household goods, furnishings, wearing apparel, jewelry, books, appliances that are used in their primary use, the debtor's primary use. Okay, and so that seems pretty easy. You know what to look for. That asset is exempt. That asset, you can avoid the lien. It gets more complicated when the next category of assets that may be avoided is tool of the trade. A tool of the trade under federal exemption is considered exactly what it sounds like. It's a tool you use for your trade, okay? Some states, including Nebraska, have an exemption called tool of the trade, okay? It gets complicated because their tool of the trade applies to vehicles that are driven to work and back to home, okay? Federal law says, no, it has to be something you use for your trade, okay? But state law says the exemption applies if you travel back and forth. There is no vehicle exemption in Nebraska separate than that tool of the trade exemption. Unlike in Iowa, where there is a vehicle exemption. They also have a tool of the trade exemption. The vehicle exemption is separate. The reason that this is important is because back in 2008, I had a case. The guy owned a semi-truck trailer, and he came in. He had a lien on his car, on his truck, from a third party that was not used to purchase the semi. The semi obviously was used in his tool of the trade. He was a semi-truck driver. So we file a Chapter 13, and I file a motion to avoid the lien. In Iowa, the only lien that was applicable to his semi-truck was the vehicle exemption. So I apply the vehicle exemption, and then I immediately file a motion to avoid the lien under tool of the trade. You see my problem. Long-standing case law in Iowa is that a vehicle is not a tool of the trade. So you can't avoid that lien because it's not considered a tool of the trade. It's a vehicle. And so and this was long-standing case law, so I said, well, wait a minute. Should the state control what's a tool of the trade, or should federal law control what's considered a tool of the trade? So I appealed the decision, and the bankruptcy appellate panel agreed with me. They said federal law dictates whether it's a tool of the trade or not. And in this case, it was a semi-truck used in the debtor's tool as a tool of his trade. I don't care what exemption was applied, the court said. We just care that it's exempt, regardless of what exemption they used. So it didn't matter if I had a tool of the trade exemption. It didn't matter what exemption I used. And so in that case, it worked out great. So the lien was avoided. Well, long-standing case law in Nebraska is that a tool of the trade is a vehicle. But the vehicles that you travel to and from work under federal law are not tools of the trade. So long-standing case law in Nebraska is now the opposite. So yay in Iowa for a case, but then I come back to Nebraska and I'm like, oh, well, that didn't work out so well, because now in this case, Cardwell, which the judge decided in 2013, it says, you know what, Iowa, you only have the tool of the trade exemption to use on vehicles here in Nebraska, but federal law says that these aren't tools of the trade, so you can't avoid any of these liens. And so the long-standing case law before was that those liens were avoidable as tools of the trade. And so it's an interesting side of the law, something that you would definitely want to know about before you were to practice it and represent a debtor in a bankruptcy. Very intricate, but interesting. And I think the right decision was made here. The only time in Nebraska now that I have ever been successful on a motion to avoid a lien on a vehicle is she was a traveling nurse. And so I was able to avoid the lien. But it's interesting because of the fact that, you know, everything that's been piled up on here with the analysis on this specific issue is huge, because really, I mean, you think about it, who's going to put a lien on a refrigerator that's the non-purchase money security interest? you know, and so, go ahead. Mechanics liens, those are placed in, yeah, no, yeah, you're right. Those might be the only, yeah, you're right. But those mechanics liens, I'm wondering if those would be, no, those would still be, yeah, you're right. Those would definitely be non-PMSIs, so yeah, you're right.
Usually for maintenance, we have one against encroacher.
Yeah, no, I understand what you're saying. Yeah, but the majority of the time, the only thing I see is the vehicles are being posted as collateral. And so that's the biggest lien avoidance issues that we have here, mainly. Finally, the other way you can remove a lien is a judgment lien. A judgment lien that's placed on a personal residence, if it impairs an exemption, a homestead exemption, then you can file a motion to avoid the lien. So a lot of times I have people who come in, they have like 5 judgment liens on their property, and I'm like, well, you're entitled to the exemption, so I'm going to file a motion to avoid all of the liens, and now all of those judgment liens that were secured in the district courts are now unsecured liens, or unsecured claims in the case. So interesting, kind of complicated, but interesting. Next, a lien strip. A lien strip is totally different than a lien avoidance. A lien strip is a tool that allows an individual to strip off a mortgage that has no secured interest. So if it's secured even up to 1 penny, you can't avoid the lien. But if it's completely unsecured, you can file an adversary proceeding, not a motion. It's a separate lawsuit within the bankruptcy setting, but you file a complaint, service, all of that, and if you can obtain a judgment saying that that lien is unsecured, then upon the discharge, so they have to complete their bankruptcy before this is effective, but upon the discharge, that lien is no longer secured on the house, and they might only have 1 mortgage. I've filed for 2nd, 3rd, and 4th mortgages before. At one point, the house was worth quite a bit, and then of course something happens, and the house is no longer worth it, and so these unsecured, you know, liens have been stripped. The case law here that I put in here, just so that you're aware of it, has been a highly debated issue in Chapter 7 proceedings, if you can avoid a lien if it's fully underwater or partially underwater. And so the most recent one you can see is Supreme Court 2015, that in the court ruled that a junior lien, even if it's fully unsecured, is not, you can't strip it in a Chapter 7. So it's interesting because it's just, again, we're back to that, what I mentioned originally was that super discharge in your Chapter 13. Chapter 13 is a tool that you can use, in a Chapter 7 you can't. So interesting. Okay, dischargeable taxes. This one, it really comes down to time frames. Some tax debt is dischargeable. A lot of people don't even realize it. They come into my office and they're like, well, I owe taxes. I know I'm never going to get out of that. Well, what year do you owe for? Oh, it was 2001. I'm like, okay, did you file your tax return? Yeah. Okay, well, give me the tax transcript because I might be able to help you out here. The general rule is that if the debt is considered a general unsecured tax debt, if the tax return was filed over 2 years ago, it was due over 3 years ago, and it was assessed over 240 days ago. So that's when we get our spreadsheets out and we're like, calculate it out, make sure that, I mean, it's all set. Priority tax debt, this tax claim is a tax return that was due within the past 3 years and or assessed in the last 240 days. This is good because a priority tax debt in a Chapter 7 just means that the debt's not going to be discharged. But in Chapter 13, I can arrange for it to be paid back over the time of the plan. A non-dischargeable tax debt, and it's also not a priority tax debt, meaning it's not going to be discharged in a Chapter 7, but I also can't provide for it in a Chapter 13, meaning when that Chapter 13 is done and over with, they're still going to owe this tax debt. It's tax returns filed within the last 2 years, but the due date was over 3 years. So you have all these weird time frames that you just have to keep track of, and I always tell people, you know, just keep a spreadsheet. I watch for these offer and compromise and bankruptcy proceedings that are intertwined within these because it'll toll the time frame that you're looking at. So just be careful. But it's a powerful tool. I actually had a guy, he was a day trader, and I think the end of the day we got him out of like over $1 million in taxes because they were old. So interesting. Anyway, he was getting heavily garnished at the time for him, so it was a big deal. Okay, next, the last tool that I have for the debtor side is a cram down. Cram down, again, applies in Chapter 13 proceedings. This basically allows you to extend the duration of a loan or reduce the interest rates in a loan to lower the obligation, make it more manageable, feasible in payments. And so that's an interesting case. This case, Till basically says, hey, a loan interest rate now is prime plus 2, which is 5.25 right now. And so all vehicles, anything like that, are crammed down to that interest rate. So I have a lot of people come in and they have 16% interest on their vehicles. You can cram them down in Chapter 13. You can't do it in a 7. So it's just something to be aware of. Yeah, and then also it allows somebody to pay back the value of an asset rather than the loan amount, and that applies to vehicles that were purchased over 910 days ago. And then cost collateralized loans secured on personal residence. I mainly only see this with business owners who took out a business loan and they were required to do a deed in trust for their home. We can cram those down to whatever equities left in the home. Small mortgages, real estate taxes, you can cram those into a Chapter 13. So if there's a balloon payment, you can get the whole amount paid in through the plan. That's beneficial. And then household goods and furnishings, there's the 1 year look back. I mean, mainly Nebraska Furniture Mart's the only one that Furniture Row, and I'll take a hit on that one. But that's just to be aware of household goods and furnishings purchased over a year ago. You can cram down to fair market value, not the loan amount. Okay, so those were debtors' powers. Okay, now let's flip to trustees' powers. The trustee has a lot of powers, and I just picked up a couple because I think these are the most scary ones and the ones that are used most often, just so that you're aware of it. But the first one here is called a preference payments. Preference payments are any payments to a creditor within 90 days of filing a bankruptcy that are higher than $600. So if you pay a creditor $1,000 right before you file bankruptcy for an old debt, trustee can go after that creditor to repay that amount. Okay, and so that's just something you're aware of. The look back for an insider, which is a family member or a business partner, is a year. So if you paid your family member your tax refunds to get them current, you want to make sure that you wait a year at least, because they could go back after those funds. The interesting about this power, though, is that the debtor gets the same power. So a debtor is not really going to care about going after Discover for the $1,000 that they paid him within 90 days of filing a bankruptcy. But if, let's say, Discover suddenly decides, hey, I'm going to involuntarily garnish you $1,000 within the 90 days prior to the filing of the bankruptcy, yeah, the debtor's going to want that money back, and they can do it under this rule. So debtor gets the same power. Next is what's called fraudulent transfers. Fraudulent transfers sounds really bad and evil, but they're not always that. Actual fraud obviously would be, you're intentionally defrauding, trying to delay collection on a creditor. Those types of actions are going to be avoidable, meaning they'll go after the fraudulent action. Constructive fraud is more likely what you'll see is what a debtor has transferred something for less than fair market value. So they're looking for people ditching assets. And so the look back that you're required to report is 2 years. And so anything that's been transferred within 2 years, I'm extremely investigatory about. Make sure, hey, you transferred this vehicle to your son. How much was it worth when you transferred it? How much did you get? That kind of thing. But you got to watch out because the trustee can also use applicable law. So you're looking at your states, the state law, and under Nebraska state law, the look back is 4 years. And so I put some cases on here that are helpful on distinguishing what that's considered and the time frames. I actually ask my clients, have you transferred anything in the last 10 years? Because technically, if they owe a governmental unit, then the look back could be up to 10 years, and it is 10 years into a self-settled trust. And so I always ask because that's really the only way you're going to know. And they're just the craziest things can come up from transfers of assets that you want to make sure you're aware of. There are defenses for creditors that are pursued for fraudulent transfer actions. I have represented creditors in this situation where I defended them under the ordinary course of business. It was a business that had filed bankruptcy, and the trustee was going after the creditors of the business entity. Well, the business that had filed the bankruptcy routinely paid at 60 days, So if I could establish an ordinary course of dealings, then that was a valid defense. Also, new value. This one's huge because a lot of times, especially with like revolving family credit situations where, hey, mom lent me $1,000, I paid her back with my tax refund, but since then she's given me another $1,000. Well, that's a good defense for that family member. So that's just something to be aware of. Okay. You guys probably already know what the discharges. I've referred to it a couple times, but it's a powerful thing. It removes all personal liability for an individual once a discharge is issued. There are some exceptions to that, like child support and student loans if there's no undue hardship, things like that. Debts intentionally not listed in the bankruptcy schedules are also not discharged. However, if a debt is unintentionally not listed, meaning you didn't know it existed, then it's possible that that could be included in the discharge. So just a difference there. But it's a powerful thing. I always tell my clients to laminate their discharge notice and keep it forever. A creditor, however, may challenge the discharge under certain circumstances. The biggest one here is fraud or false pretenses. So a lot of times you see people alleging you lied on your credit application. You told me you made more than you did, that kind of thing. Willful or malicious injury to another. I can't even think of why this would come up, but I one time had a guy who was ordered to return a motorcycle to his ex-spouse. And before he did it, he destroyed it. And so that was obviously a malicious injury to another. Fraud and false pretenses, I see that a lot with businesses, like a business entity who took an order, took a deposit, and then in the meantime, before they were able to deliver product, went out of business. You know, you see a lot of those come up where there wasn't, you have to prove intent there, and you have to be able to establish intent, and that's the biggest element with fraud and false pretenses. Also, any purchases for luxury goods over 600. So I ask them, say, airline tickets, cash advances, hotel stays. Where were you in the last 90 days? And cash advances are also subject to challenge from the discharge. Reasons for denial of discharge. These are the obvious. You did something bad. There's some false statements. Bad acts are mainly some of these things. There's also negligent acts. You failed to file schedules. You failed to take financial management. Those types of things are all things that can be reasons for a denial of discharge. And so those are just something to be familiar with. Finally, I did have a slide here that were common things that I see all the time that I was going to discuss with you, just things to look out for if they come up when you're in a situation where you're talking with somebody or a follow-up appointment with somebody and these things come up. So I can go through each of these, or I'd be happy to address any questions if there are any questions at this time. I don't know how to tell them. Yeah.
I guess in general it's on the practice itself of representing debtors. Is your practice saddled with collecting from more clients than not after the fact?
Good question. The question is, are you, as a debtor's attorney, stuck with having to collect from those debtors after the fact if they don't pay you? Well, standard practice is that in a Chapter 7 setting, we require all payment ahead of time. Because of the fact, not only will we not ever, I don't know if we'll ever get paid, but technically we are prohibited from collecting from them after the fact, because once a bankruptcy is filed, we're a creditor. And so we wiped out ourselves. In a Chapter 13 setting, it's different because you're paid through the plan. So the debtor, as long as they're making the payments, you're getting paid. And so you try and guarantee as much payment as possible. I mean, yeah, there's always those cases where they're like, save my house and file a 13, and we file and save a house. And they never make a plan payment, which means I don't get a dime. That happens, for sure. There's really not much you can do. I mean, even if you wanted to, you can send them a bill. And so you're kind of stuck with that. A lot of the times, if it's an emergency situation, we try and safeguard it somehow by charging slightly more up front, because it is a big service to do so. But there's been a lot of times where I've filed, you know, completely because of the fact that they were desperate, and I just couldn't let them lose their house on the eve of their sale date, and I never hear from them again. So it happens, but most of the time, get the money first. Good question. Anything else? Anything about lien avoidance? You guys want to talk about that? No.
Landlord tenants, as far as their leasing or renting a home that they file for bankruptcy, can they list the landlord on there, or how do they find this special?
Right. Okay. So the question is if a debtor is a landlord or a tenant and they have a leasing agreement with a landlord, is the landlord listed as a creditor? What's the ramifications on that? Technically, eviction proceedings and things like that are not necessarily protected under the automatic stay. It is possible, and most of the time I should say, procedurally speaking, most attorneys for landlords do not feel comfortable, a lot of judges in state court do not feel comfortable doing orders without a motion for relief from automatic stay so that they can proceed. There are safeguards that you can do. I actually have researched this issue. There are safeguards there's something in the code that allows for you to post like kind of a bond at the bankruptcy court if you want to retain you're being evicted, something like that. But technically, it's not protected from the automatic stay. I don't ever offer a client a guarantee on that because, like I said, a lot of the times even if they're on the eve of being evicted, the attorney for the landlord will file a motion for relief or some sort of request for permission to proceed, even if they don't have to. I mean, most people err on the side of not violating the automatic stay no matter what, because they know they can get slapped with sanctions and things like that. So, but that's a good question. Yeah, absolutely. Yeah. Oh, I always do. And in fact, you know, a lot of people say, you know, just by filing bankruptcy, you have something in your paperwork that says that I've automatically broken my lease. Like, well, you technically have, but as long as you remain current, your landlord's going to be completely happy. They want your money. They don't want the space to be vacant. There are always exceptions to that rule. I mean, I've had so many clients that have asked this question, never had any issues. In the entire time I've practiced, I've had one client who she was evicted, and there was other reasons, you know. I mean, most landlords, I tell my clients all the time, just go to them, tell them you plan on keeping major payments. They're not going to kick you out. Anything else? If you want, I can go through some of these things. Or we'll wrap it up. Yep.
Debt Collectors Act.
Mm-hmm.
To deal with that, any of the.
There are issues that come up with that, of course, and a lot of the times that's a separate legal matter, and we do refer them to people for that specialized field. It's interesting. Every time I want to you know, to take action. Recently, we've had a lot of people collecting on debts that I can't identify. They just start calling and harassing these people, but they have no physical address. I can't serve them, and so I can't get them with any type of violation of the automatic stay or violation of the discharge order. And so that's been the biggest annoyance factor recently, is that these pop-up places, they pop up and then suddenly their phones are disconnected as soon as an attorney's been contacted, and they have no address. So, but no, typically we do refer those types of things to somebody who does that type of, you know, specializes in fair debt collection acts. Mm-hmm.
So junior liens and lien stripping, 13, they do get stripped and avoided, but 7 never.
Right. The Supreme Court ruled on that just recently, saying that you cannot avoid or strip a lien if it's considered a secured and allowed claim. The question I had when I first read that is, what if I dispute the secured and allowed portion? Can I strip it in a 7? There's been no ruling on that, so at this point the rule is in a Chapter 7 you cannot strip even if it's fully underwater. Yes.
What about ones that your client might want to reaffirm for some reason? What do you generally say to them about that sort of situation?
Okay, reaffirmation agreements. Reaffirmation agreements are only, I'm sorry, the question was, what do you advise clients on reaffirmation agreements? Reaffirmation agreements are only offered in Chapter 7 proceedings, and basically it's normally by a mortgage holder or a vehicle lien holder. They'll send they'll send a reaffirmation agreement saying, I want you to have your client sign this so I have added reassurance that they're going to pay on it, and if they don't pay on it, they're forever liable. I don't care if there's been a discharge on the debt. They're signing themselves up for personal liability by signing that reaffirmation agreement. So obviously, I see them as very creditor friendly, but there are benefits to signing reaffirmation agreements. For instance, the creditors will report positively on credit reports that they've made their payments on a timely fashion, if they do so, hopefully. And so there's the benefit, and some lenders will refinance down the road if they see that you've reaffirmed your debts, because you're personally liable for those debts now. However, sometimes I see it where a client has reaffirmed a debt and suddenly they lost their job and they can't make the payments, but now they're personally liable for the debt even though they've gone through the bankruptcy. And so oftentimes I say, you know, before signing any reaffirmation agreement, you want to take a hard look, because the worst case scenario can happen. I've seen it a lot. And so you don't want to sign a mortgage where you don't have any equity. You don't want to sign a car note where you don't have any equity, those types of things. If you have a lot of equity, there's probably not a lot of risk necessarily by signing it, assuming that you have a stable job and you don't have any reason to believe that you're going to lose your job. But I've had more people call me saying, I'm so glad I didn't sign that reaffirmation agreement, because now they're not making payments and they're walking away from homes and things like that. And in Nebraska, a lot of the times if you can't show that that client can make the payments, the judge won't even approve it. And so then you're stuck. Even if they have signed it, the judge will say, no, it's not in your best interest. You can't even show me on paper that you can afford this, and you don't have any equity. So there's no reason for you to re-sign your obligation on the biggest debt you owe, you know, a house loan or something like that. So Good question. Anything else? Yeah. Good question. The question is how do you determine how long the duration of a plan in a Chapter 13? First off, if they're above the threshold median income and they have disposable income, if they're in a mandatory 5-year plan, which is what you referenced, that you knew that that was the case. If, however, they do not have any disposable income, they're not in a mandatory 5-year plan, so you can run that plan anywhere from 3 to 5 years if you wanted to. A lot of the times, there's a reason that a 5-year plan is still necessary because it makes the payments lower, more feasible for the person. If I can shorten it to 3 years, I always do. Or if, let's say, they're not in a mandatory 5-year plan, we start off with a 5-year plan to keep payments low, and suddenly they start making more money. Then I'll go back and amend to lower it to a 3-year plan. So there's lots of reasons, advantageous reasons for doing one or the other, but it really comes down to feasibility. Can they afford to be in a shorter duration of a plan? Depends on what they owe, depends on what they have to pay back. Good question. Anything else? Well, thank you.